question about whether.
Yep, we did have one question and we answered it.
Okay, great. Thank you, Jenna.
Mhm.
Okay, let's get started. My name is Pat Caraher. I'm the managing attorney of the Lincoln Office of Legal Aid. And I see we still have people logging on here, so we won't start the official presentation for a minute or two, but I wanted to make a few comments. First of all, really have to say how pleased we are with the number of participants registered. I think we have over 150 people registered for this protection order presentation. Really happy to hear from people from all over who have registered for this presentation, and I hope it's helpful because obviously there's a lot of interest in protection order law. I also should say this webinar is made possible through the City of Omaha ARPA Community Grant Program. So Legal Aid extends a huge thank you to the Omaha Community Foundation for making this webinar possible. I also want to say a few words about Legal Aid. We've been providing free legal assistance to low-income people in civil cases for 60 years. Domestic abuse has always been a high priority at Legal Aid. We have always given that our highest priority in terms of case acceptance. However, I frequently get asked, is Legal Aid doing divorces? Is Legal Aid doing custody cases? Is Legal Aid doing child support cases? And the answer is complicated. Depends on our funding, depends on our caseload. We have 7 offices around the state. One office might be able to take those cases, another might. I will tell you that because of the grant from the Omaha Community Foundation, our Omaha legal aid clients are being served in custody cases and divorces right now, and they weren't until we had that grant. But the bottom line, if you know someone who needs help with a domestic violence situation or a domestic relations case at all, please refer them to Legal Aid of Nebraska. We will help them as much as we can. We do have a lot of experience with protection orders, and that's what we're going to be talking about today. I also want to point out another thing. As you hear the presentation today, I will guarantee you some of you will say, well, that's not how the judge in Papillion did it, or that's not what I saw last week. Probably no civil case is handled in such a variety of ways as protection orders. And some of that is okay. The Nebraska Supreme Court has given judges a lot of latitude to handle these cases as they see fit. On the other hand, the law is the law, and judges should do certain things in every case. And we're going to talk about that today. We have 3 attorneys here from Legal Aid today. First of all, me again, I'm Pat Caraher from the Lincoln office. I've been the managing attorney of the Lincoln Office of Legal Aid since 2009. I've been at Legal Aid since 1987. So in my 36 years at Legal Aid, I've handled a large number of domestic violence cases. Also pleased to have Mark Bestel with us today. He's been practicing law for over 20 years, has been at Legal Aid since 2007. Mark is Legal Aid's appeal specialist, and he has done extensive work representing victims of domestic violence over the last 16 years. Mark will be going through the nuts and bolts of our protection order law with our PowerPoint presentation. Also pleased to have Elaine D'Amato with us today. Elaine has been a family law attorney at Legal Aid for 22 years. She specializes in domestic violence cases, including protection orders, divorces, paternity cases, custody, visitation, and child support. And on a personal level, Elaine is a survivor of 14 years of domestic violence during her own marriage. After her divorce, Elaine had to petition the state of Florida to be able to leave the state in order to attend Creighton Law School. Elaine just has a lot of real world experience, and she will be giving us some real world tips on how to prepare for a protection order case. So the three of us attorneys have close to 80 years of combined legal experience, which I hope is useful for this webinar. I also don't want to leave out Jenna Heineck, who's on the call today. She is our communications manager at Legal Aid. She does a great job with things like this webinar. So thank you, Jenna, for getting us here today. And Jenna told me that I need to remind people that your audio is off. and it will stay off, okay? We would love to address questions, but you cannot orally ask anything during the webinar. Please put your questions, your comments, your suggestions in the chat. We encourage that. We want some interaction, and we will address those things probably at the end of the presentation, but possibly throughout the presentation. We'll just see how that goes. Also, this webinar is not registered for continuing legal education credits for attorneys. We wanted this to be open to attorneys and non-attorneys. We will be doing a second webinar in the near future directed at attorneys, and that will include continuing legal education credit for lawyers. Okay, I'm going to turn things over to Attorney Mark Vestal. Again, Mark is our appeals specialist. He's done many appeals involving protection orders, so he has a very deep understanding of these issues. Mark, please take it away.
Thanks, Pat. First of all, I'm very happy to be presenting today about this topic. It's important to me. It's an important aspect of what Legal Aid of Nebraska has done. We've had various types of grants and funding over the years that specifically are for funds to represent victims of domestic violence, and so that is a huge part of what our family law unit does. I have done hundreds of protection order cases over the years for Legal Aid. As Pat mentioned, I've done some appellate work that deals with these issues as well. And does that make me an expert on this stuff? I don't know. I will warn you, I am not good at PowerPoint. I've never done a PowerPoint over Zoom before. So there's a good chance I might just like hang up on everybody and screw this whole thing up. But hopefully, I think I can just tap through the slide presentation. And I guess I wanted to start by just making sure everyone can see the screen that says Legal Aid of Nebraska, the big 60-year celebration banner and introduction to protection orders in Nebraska, that's on the screen. Is that there? Let's see. Yes, we can. Somebody says in the chat. Excellent. All right. So I now want to start the slideshow. There we go. So this is, how do I get rid of this here? There we go. This is our statement, our land acknowledgement statement that we have been presenting over, that we, as an organization, the following federally recognized tribal nations have connections to the land currently known as the state of Nebraska as the original inhabitants of this land, and or through the practice of forced removal. And so we had felt it is important for us as an organization and to acknowledge this. And there are quite a few of them there. So here's our mission statement. It's to promote justice, dignity, hope, and self-sufficiency through quality civil legal aid for those who have nowhere else to turn. And that is the truth. Most of our clients have no ability to afford an attorney, and legal aid does a lot of types of legal work that really there isn't a private practice equivalent, just due to the nature of sort of the issues that people who are in poverty are facing. So it's an important mission, and we do our best to maintain that at all times in all that we do. All right, we are Nebraska's largest nonprofit law firm. We service every county in Nebraska at some way or another, and we have offices throughout the state. And here we go, starting on the protection orders. This is, there are 3 types of protection orders. There are domestic abuse protection orders, sexual assault protection orders, and harassment protection orders. And you can, a victim can obtain one for whichever setting best describes the acts of abuse that they suffered. And there are certain, and we'll get into that, certain sort of requirements for each one, and what you have to prove going into court for each one. It's a little bit different. But all of them are like an injunction. So if you've heard the term injunction before, I know that there's a lot of non-lawyers, and I sometimes forget that we have all kinds of funny words that we use every day. But an injunction is the idea of preventing something from happening in the future. So you can get a court order for an injunction for, in other contexts, not to sell a certain piece of property during a contract dispute or something like that. And protection orders are similar in that sense, in that they are requesting that behavior not occur in the future, and that a person is enjoined or prevented by this protection order from acting in the way that they had in the past that led to obtaining the protection order. Here we go. Protection orders, whole screen. Okay, so here are the three types that are set forth in the Nebraska statutes. Each one is in a different chapter of the statutes. Well, sexual assault and harassment protection orders are set forth in the criminal statutes, even though that, and then the domestic abuse protection order are sort of set forth in the family law household statutes. And there's the reason for that is because you have to have a relationship with the person to obtain a protection order. But these are the statutes that authorize them. So for a domestic abuse protection order, the statutes define what domestic abuse is, and then anyone who is a victim of domestic abuse may file a petition for a protection order as provided in the section. And then it says affidavit. So that's part of the application process, is a sworn statement describing the events that occurred. Those issue for 1 year, the domestic abuse protection orders in the state of Nebraska. Other states, the terms are different. So all of this is dealing just with the state of Nebraska. And then a person may seek a renewal at the end, towards the end of that year period of time, to have it put in place, or to keep it in place. Sexual assault protection order. Sexual assault is again defined by statutes, and it's defined by the criminal acts, what constitutes sexual assault. And they may seek a sexual assault protection order. And those are also allowed to be renewed if at the end of the year period of time the victim still feels protection is necessary to keep themselves safe. They may seek an additional additional time added on to that protection order. Harassment protection orders, they are not renewable, and those are for people who have been harassed, and that also is defined by Nebraska law, by statute. What does it mean to be harassed? But anybody who has been harassed under the definition may seek the protection order. All right, next slide here. So this describes more the sort of requirements or what you have to show in order to obtain these different types of protection orders. So first, on the left, we have the domestic abuse protection order. So one or more of the following acts has occurred between a family or household members. And now, household member, family or household member, that can actually mean somebody in a dating relationship that you're not living with, So it's not limited to people just in your house, but it's attempting to cause or intentionally and knowingly causing bodily injury with or without a dangerous instrument. That is an act, and that act alone is enough to justify obtaining a protection order against somebody, a domestic abuse protection order. Or you can, by placing by means of credible threat, a person in fear of bodily injury. So just by making threats that threaten in bodily injury, or due to the relationship is strongly implied in what they're saying, that is enough to obtain a protection order, domestic abuse protection order. And then so in engaging in sexual contact or sexual penetration without consent. So that starts to sound like sexual assault protection order, and that has been in there longer than we've had the sexual assault protection order statute. But then this also is a means of obtaining a domestic abuse protection order as well. Now, the sexual assault protection order doesn't have the requirement of being between family or household members or having a dating relationship or anything like that. It is conduct that amounts to sexual assault under the criminal statutes, sexual abuse by a school employee, sexual assault of a child in basically any type of sexual contact there is defined by the criminal statutes, or sexual contact or sexual penetration without consent. And so any of those acts occur, a person can obtain a sexual assault protection order against that person. And so there are times maybe where a person may have to decide between the domestic abuse protection order or obtaining a sexual assault protection order. And I've had that situation happen because they were within the definition of a household member, but they opted to pursue the sexual assault protection order because that was the only type of abuse that person suffered, and it was more than once, happened quite a bit. And then the harassment protection order is, so what harassment is in a nutshell is knowingly and willfully engaging in a course of conduct that seriously terrifies, threatens, or intimidates somebody, and it serves no legitimate purpose. And so that's sort of a broad painting of what could be that, because what seriously terrifies and threatens or intimidates me may be very different from what that is to somebody else. And then and obviously just to pester someone or to make somebody's life horrible or seeking revenge or whatever it is, those are not legitimate purposes. And I can't really imagine what, if you're doing these things and it does seriously terrify or threaten or intimidate somebody, what the legitimate purpose is, unless somebody was really misinterpreting behavior. The mailman is delivering mail every day and that's terrifying me. That probably a judge would not consider that to be harassment, even though the victim feels that it is. And so that's one of the things the court sort of is asked to do when you're presenting evidence, is to determine, is this course of conduct really that is something that would seriously terrify, threaten, or intimidate people. Let's see. Okay, so here now we talk about the people who are what a domestic family or household member would be under the protection order, domestic abuse protection order statutes. So spouses, former spouses that don't live there anymore, children, your own, children that are of an age to cause harm or threaten you or attack you, intimate partners, past or present, people who have a child together, dating relationships, past or present, roommates, other persons related by affinity or consanguinity. And that consanguinity means blood, and affinity means like by marriage. So a mother-in-law, you could obtain a protection order against your mother-in-law if you needed to. Domestic abuse protection order. And then consanguinity means related by blood, cousin, that sort of thing. So then when we get over to the sexual assault protection orders, so the sexual contact reasonably construed as being for the purposes of sexual arousal or gratification of either party, which so in the one of this case here that's cited, that's for those of you that don't know, that's how we cite to Nebraska Supreme Court cases, or in this case actually a Court of Appeals case, and that was a case that decided and dealt with the issue of what constituted sexual assault, and slapping a woman on the rear end was sufficiently enough to be considered sexual assault in that context. And it meets this definition of without consent, and the action itself. So, and we look there, the force or threat of force or coercion, lack of consent through words and or conduct, actors, deception as to the identity of or the nature or purpose of what they've done, knew or should have known that the victim was incapable of resisting or apprising the nature of his or her conduct. Now, the harassment protection orders, excuse me, the pattern of conduct, that's I think a lot of the times where these sort of fall short, that it's, is just calling someone 5 or 6 times over the course of an hour or two, while it feels harassing, is that going to be harassment under the meaning of the statute there? And it may or may not be, just depending on what was said, if anything, or the purposes of those calls were for. So the pattern of conduct is a series of acts over a course of the span of time, and the statute even says, however short, evidencing a continuity of purpose. And so, I guess I would think that a course of conduct like over 5 minutes would probably not actually be interpreted to be sufficient to be considered harassment. Somebody sent you a barrage of text messages, but again, depending on what they say, maybe it could be. And of course, this doesn't have to be against anybody you even know, or that you live with, or have any type of relationship at all. It can be, just somebody who's been, suddenly picked a fight with you somehow, or has some anger or hostility towards you, accuses you of cutting them off on the road or whatever, follows you around, starts showing up places where you are, that sort of thing. And that's listed here is the series of acts, the pattern of conduct that includes a series of acts. So which is following, detaining, restraining, stalking, telephoning, contacting, otherwise communicating, and then, so like just once wouldn't probably be harassment, maybe just twice wouldn't, but when somebody starts phoning you, yelling at you for doing whatever it was that they didn't like, or whatever problem that they have, or just trying to get your to notice them, or whatever it is, that starts to look more like harassment. So domestic abuse protection order, we've talked about this a little bit already. A relationship is required. That's one of the main things. And then so it sort of changes, you sort of kind of look to that relationship in some senses to the victim may in that knowledge of that other person can be used in sort of predicting or causing the person to have fear, knowing that this person, well, gee, I know him to have been violent towards me in the past, that or to other people or to his other significant relationships, he's been violent or threatened violence, and that makes me fearful for myself. So that relationship is required, but you don't have to show any sort of pattern or repeated behavior. It can be one thing as long as it's within that definition of what constitutes abuse, domestic abuse. So one of the things that a domestic abuse protection order, or some of the other things that a domestic abuse protection order can do that other protection orders don't have, is this idea of 90 days of custody with children in common, up to that amount. If the court feels that it's, if there is no, well, if there's children involved and somehow they were exposed to the violence or the abuse, and oftentimes the court will grant some temporary custody for the victim over the children. The protection order can order the other party to be removed from the residence, no longer being able to live there if they're still living together, staying away from various places, home, school, work, no contact at all, or can specify when they can contact. We can contact to talk about the well-being of children, and then other relief to ensure the safety and welfare of petitioner. But I wouldn't go so far as to say any other relief, because a lot of times my clients will want all of their belongings in a protection order case to be ordered back to them, and the judge isn't going to do that. I get the car, I need the car to drive to work and keep myself safe. Well, that may be true, but that's not something the court is really going to do. So it's not any other relief, but relief that would be related to the safety. And the court isn't going to order, in a protection order case, anybody to attend sort of therapy or take anger management classes or domestic abuse, counseling or anything like that. A protection order isn't going to order those types of things. Sexual abuse protection, and I'm speaking, of course, of the domestic abuse protection order. Well, any of them aren't going to order anything like that. But so sexual abuse protection orders, no relationship is required. You do not have to know the person at all, and just one act is enough. And it provides the relief to the victim against the respondent or the abuser, but the parties' names on these protection orders, the victim fills it out as a petitioner. They petition the court for this relief, and then the abuser is the respondent. And the relief that in a sexual assault protection order is to impose, the respondent cannot impose any restraint upon the victim, harass, threaten, assault, disturb the peace of the victim, telephone, contact, communicate with the victim. Even if they are, if a sexual assault protection order is brought by people who have children together or are married, the sexual assault protection order does not have provisions to allow for the temporary custody of children. Harassment protection orders, no relationship is required. We've talked about that a little bit already. We talked about show the course of conduct over a period of time, no matter how short, evidencing a continuity of purpose. So all the communications are about this issue, this same thing. You cut me off on the road, you're going to pay, blah, 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 whatever that is, and harassing over and over, then that, but if it, so you have to show those things. Provides the same specific relief as a sexual assault protection order. So these things over here can't impose any restraint upon a victim, what I already went through. And again, no provisions as to why won't this go away on my screen? Anyway, I think there are people are asking questions. So I don't know.
Mark, we do have some questions. I don't know if you want to answer some of them now or if you want to wait till the end.
Let's wait till the end and we'll get
Okay.
through then maybe some of these will be answered if we go through everything else.
Sounds good.
Without knowing what the questions are, though. I don't know what they are, but I'm going to go ahead and proceed. So, not a protection order. So there are other orders that courts, judges can issue in certain kinds of cases that also provide some level of legal protection against victims. One of those is a bond condition, a no contact bond condition. So if somebody has been the victim of domestic abuse and the person is, the abuser is charged criminally and is out on bond, the bond will specify that the person know the abuser not contact the victim. And that could be, but that could be in any other types of criminal cases too. It doesn't have to necessarily involve domestic violence. It could be the victim of, not to contact the victim of any crime, if there was a reason for the court to put such a condition in place. You know, you don't want to intimidate your accuser, those sorts of things. It does not have the same protections as a protection order. The person who prepared this put in not an arrest if no contact violated. Yeah, maybe not necessarily, and it's not a quick process if the provision is violated. The bond can be revoked and the person put back in jail, or more restrictions can be placed on the bond, and that sort of thing. But yes, there are, but there's no, no, it's not as it doesn't have the same effect with law enforcement, I think, as a protection order would. All right. Restraining orders. So in the divorce statutes, there are a provision for temporary restraining orders. And so if somebody's getting a divorce, they can seek temporary orders restraining a person from doing certain things like, you know, selling all of the things in the house, or you know, other things. But also it can provide for to not contact, and not, you know, disturb their peace, contact them, bother them. And then yes, and then usually the courts will enter those as a mutual restraining order. And the provision that sets out the terms of restraining orders is about temporary restraining orders. Violating a temporary restraining order in that statute talks about is a class 2 misdemeanor. So a person can be charged with the crime for violating a temporary restraining order, but it's not again, it's not as quick of a process. I don't have the data about that though, if the provision is violated. Now, I say temporary restraining orders. Now they're in, you know, when you go forward and get a final decree of dissolution, or in a custody case, there are, you know, particularly when there's children involved, there are opportunities to provide in those documents what needs to be done to keep the parties safe, and you can set forth these same terms there. But I don't think that violating the terms of a a parenting plan that provides for mutual safety of the parties, mutual restraining order is going to be a criminal charge. The criminal charge is when for violating a temporary restraining order. That's what it says in the statute anyway. All right. Getting a protection order. And I think Elaine is going to talk about this when I'm all done. But here is the forms. They should be available at every district court clerk. Maybe they're not at some, but any sort of domestic violence center would have them. The Supreme Court website has them. Advocates have them. They must be completed by the victim and be in English. You may use an interpreter and translator if the person is non-English speaking. And then the English statement should be attached to it. The petition, and this is the this is the affidavit part. The person puts in the allegations, which would be the most recent occurrence of abuse, the most severe occurrence of abuse. The succinct statement of facts should be detailed, not include things not related to the abuse. There are a lot of, but it's hard for some victims because it all is tied up, particularly when it's a domestic abuse protection order, and the whole relationship is sort of revolves around this dynamic of abuse. And so everything feels abusive, even though it may not be acts that meet the statutory definition of abuse. It is sometimes hard for victims to separate those things out. So this is all about how to get the protection order. Again, Elaine's going to talk about this when I'm done, so I'm going to kind of skip through some of this. One of the important things is that there is no filing fee for a victim to file, unlike any other court case that you're starting. There's no filing fee unless the court determines that after an evidentiary hearing and makes specific findings in its order that the person brought the action in bad faith and made false statements in their affidavit to obtain the protection order. That they were brought in bad faith, meaning using that process for some other reason other than protecting themselves, like to cause problems for the other person, to make or whatever it would be. And then if after the hearing, evidentiary hearing, the court can assess the costs to the respondent or abuser. There was one judge that would do that sort of routinely, and he would assess if the protection order remained in effect. The court would assess to the respondent. If the protection order was dismissed after an evidentiary hearing, he would assess the cost to the petitioner, even though he didn't make those findings that he needed to. And that was one of the appeals I did, where I got that aspect of that decision reversed for failing to make those findings of false statements in bad faith. You file a petition with the clerk of the district court. Should file it in the county where the events or some of the events took place. This comes from the general filing statute. Where do you file a lawsuit in Nebraska for any type of lawsuit? This tells you where. There are certain types of cases that have to be brought in a specific district court of a certain county, particularly in family law cases. Paternity cases need to be filed at a certain place. Divorce cases need to be filed at a certain place. But this is the general venue or location of where you file requirements. So once someone's filed a petition for a protection order, put their allegations in their affidavit, and the petition and the affidavit are one form. They're submitted together. The court looks at it, considers it. If it looks like, based on the facts, like immediate danger is likely, the person will issue an ex parte order or an order without the parties. That means the court just makes a decision without having everybody there at court. Looking at the sworn statement. And then, or if the court doesn't enter an ex parte order, the court then just sets it for a hearing. There's no protection order in place pending the hearing. But if the court issues an ex parte order, there is a protection order in place that may or may not continue depending on what the respondent does. So protection orders are not enforceable against the respondent until they're served. They're personally served by the sheriff. If they disagree with that, they must request a hearing within 10 business days of being served. So usually about 2 weeks, depending on the day of the week and the holidays and things like that. And the ex parte order remains in effect till the hearing. If the respondent is served and does not request a hearing within the 10 business days, the protection order is deemed to be a final order. It's the protection order. It remains in place without having any hearing. If the respondent has requested a hearing, the court sets the matter for hearing, is required to set the hearing within 30 days. And then the hearing will be on whether the ex parte order should remain in effect. Petitioner has to show that the events are true. So that's what their burden is when the ex parte order is. The judge has read the affidavit, the events described in the affidavit in the judge's mind describe abuse. So the hearing on an ex parte order becomes whether those events are true. And then the burden shifts to the respondent to show cause as to why the protection order should not remain in effect. And there are reasons sometimes where the court determines that that should not happen. If there's no ex parte order issued, the burden of proof is a little bit different. Is a little bit different on the. It's all on the petitioner to show, one, that abuse occurred, and prove that abuse occurred, and that a protection order is needed going forward in the future to keep that person safe. All right. So protection order hearings can be, if you're going and practicing in different hearing counties, and or if you are one is a victim in a particular county, what is expected of them at the hearing may vary a little bit, because these are limited hearings. Because they are basically an injunction, the court has the ability to sort of limit the time that is allowed for a hearing, so you don't necessarily get a full-blown trial where you're calling a litany of witnesses for days and days. That's not going to happen at a protection order hearing, even if those witnesses are all have relevant testimony. The courts can limit what you're doing, and so it's a good idea if you're an attorney and you are practicing in a county that you have not practiced in before, to do a show cause hearing on a protection order, to talk to the judge to see how ahead of time, how they want you to proceed, who gets to go, because some of the courts, just even judges, even in the same district, will do it a little differently. Sometimes they want the petitioner to speak first. Sometimes they want the respondent to speak first. It is sort of an up in the air. Sometimes you just don't know where the judges are coming from and how they're wanting to the evidence presented at those hearings. So in this Torres versus Morales case, that's a case that I did on appeal. The Nebraska Supreme Court has stated that the procedural due process is afforded in a protection order hearing is limited because of the intrusion on a respondent's liberty interests is likewise limited. So there are, well, the court can limit questioning. The court can limit the time, as I said, the amount of time allowed for each witnesses. I've had judges tell me you each get 20 minutes. I've had judges tell me that I can't call other witnesses, and there's not much you can do when that happens. And I've had judges, after just asking some questions, and that was this case here, Torres versus Morales case, where the judge sort of cross-examined the respondent and then just walked off the bench without allowing me an opportunity to do some things. And that was an issue I raised on appeal, and that was why they ordered this way that they did. That the courts really do have a lot of leeway in how they proceed on those hearings. And so it can be a little confusing, particularly if somebody's representing themselves. A victim of domestic violence is representing themselves. So the procedures at a show cause hearing might be less elaborate than we just sort of talked about, and then commonly used in civil trials. So, but at a minimum, the testimony must be under oath, documents admitted into evidence before being considered, instead of just talked about, or in the case that's cited there, the Nebraska Supreme Court's case on Mahmoud versus Mahmud, was the court took judicial notice of the affidavit instead of receiving the affidavit as evidence. And if you're not a lawyer, that doesn't probably mean much to you, but what it means is that that's not on the record on further review of the case on an appeal. So there's that document isn't being reviewed by the appellate court. Well, and this says harassment protection orders. Yeah, so where the evidence is insufficient, the appellate courts have reversed and vacated, and that can be for any number of reasons. Either there's no evidence in these harassment protection orders of a pattern of behavior or a series of events, or that the behavior was threatening. So there's any number of reasons a court can dismiss on appeal what the lower court put into effect. So after the hearing, trial on the protection order, the court makes findings. If the ex parte order was entered, they affirm it for a year from the date that the order was originally issued, can modify the terms if somebody has moved or if there's got a new job, but it's still from that 1 year from the original date being issued, or the court can vacate the ex parte order and dismiss the petition. If no ex parte order was entered and there was evidence at the hearing, the court can either enter a protection order valid for 1 year from the date that protection order is entered at the hearing or after the hearing, and then, or they can dismiss the petition if the evidence suggests otherwise. You can modify the protection order. I'm running out of time here. I'm going to skip through some of this stuff. You can vacate the protection order. You can renew the protection order. And we talked about that a little bit. So anytime for a sexual assault protection order or domestic abuse protection order, within 45 days of those orders expiring, the victim can seek to have those orders renewed. And the process is a similar process to what they did originally, the new affidavit, but they do not need to allege any new events. So the fact, and a lot of people will argue this, that the fact that the protection orders have worked is not evidence as to why it shouldn't be renewed. So I've done these renewal hearings where the other side or their attorney has argued, well, look, there's been no contact, nothing's happened, there's been no other events, and that's not the reason not to renew it of and by itself. So no new abusive act or even contact has to have occurred in order to obtain those.
And Mark, I think we have to move along to
Yeah.
Elaine. I know she's got some materials that she wants. And I believe, Jenna, we are sending out, people could get this presentation if they wanted to. They could get the PowerPoint. Is that right?
Yep, so we can keep going, and if people need to hop off of the call, then we will send out a recording of the presentation along with the slide deck and any other supplemental materials. And if you have a question, feel free to put it in the chat, and then we'll also send out a document that has all of the questions and answers in it as well. So
Great. And I just want to make sure Elaine had a chance to talk about some of her stuff. So Elaine, you want to fill us in on your
Sure.
information?
Sure, I'm just giving you some practical information, because if you are assisting a client that comes in and talks about an abusive situation, then you would know to direct them to, a certain organizations like Legal Aid or all across any domestic violence protection center. But when you do fill out a petition, this is where I'm really just coming from. It's very important to understand it's under oath. So your statements should be true and that you could back them up. How you back up your statements are with text messages. If the other person sent you really bad threats to take your children, threats to harm you, you would want to attach things like that are pretty much current, backing up your statements. And you want to always, you need to put recent things and serious things first. There's like 3 or 4 paragraphs allowed in the form to fill out. You want to put the most recent. Some judges will not go back past 6 months. So you want to, they'll say, well, what if it was so bad? Why didn't you come in 5 months ago, a month after it happened? So you want to current things, the most recent and also most severe. Put dates, times, and who was there. My sister was there with me and she witnessed this. Those are important. And then at the hearing, that sister would need to come and testify. So if there's a police involvement, like someone got hurt bad, they were physically abused, you call the police. The police took pictures of her bruised face, okay? You cannot get those pictures from the police. Take your phone and get a picture of the bruises yourself, because you cannot get the police pictures. Take your own. Everyone has phones these days that take pictures, and also the next day take pictures, because bruises will change color. Unfortunately, people of color have a difficult time with bruises showing up. So be careful how you get photos that way. If you go to the hospital, the ER, and you're just being checked out, get a discharge note, form, whatever they give you, discharge instructions to go home with. Take that, keep that. You can attach that, or you can bring that to court to show that you had to go to the hospital. Emails, texts, all of those things, but be careful what you use. You don't want to attach, 15 text messages. You make sure that if you're giving the court a text message, that what you said on it is not just as bad as what they said. You use curse words and whatever, it's going to negate the other person's threats. So be careful, whatever you write down ever can be used against you, text message, email. But to use for the court information, you want to, have something that other person said, threats. I'm going to get a knife to your face, whatever. I'm going to shred all your clothes hanging in the closet, which has happened. So you have to make sure that, whatever you attach is good. You can take pictures of holes in walls. If you punched a hole in the wall and it missed your face, but it was directed towards you or to put fear in you, take a picture of the hole. Don't fix it. Take a picture of it first. Smash the door. take a picture of it. Okay, children on the protection orders. A lot of people will put their children as parties. A lot of judges will not grant the protection order as to a child if the adverse party, the person that's causing the abuse, is the parent of that child, because that would interfere with visitation. But you can still put it there. I know we don't think that, most people think that if a child is there and witnessing two people fighting, throwing things, that child, even if the child doesn't get hit, they are emotionally and psychologically abused. A lot of courts don't go with that. If the child was hurt, like the father threw a bottle and it smashed all over and the little boy got cut, then that would be a physical abuse to the child, and that would be maintained. But you can go ahead and put kids on the protection order, and the judge may not. It depends on your allegations. Another person that lives in your house, say your sister lives with you, she cannot go on the petition if she's an adult. So that person would have to get their own protection order. Okay. Very important, if you do file a protection order, it gets granted as an ex parte. The other person asks for a hearing. They have 10 days to do that, and then you'll get notice of a hearing. You do have to go to that hearing. Even though it's like a temporary, the ex parte is a kind of a temporary order. So you have to go to get it for a whole year. Please go. Please don't ever dismiss a protection order. I will not dismiss a protection order for a client. It shows up on your record that you took out a protection order and then you dismissed it. A lot of people get back together. I understand that, but you need to know in the justice system, which is our court files, it will show all the times you've applied for a protection order and then you've dismissed. Basically, when you dismiss something, you're saying that's not true. And if you put your name to the petition, you need to make sure it's a true statement, everything you do. Also on service, they'll ask you on the form you fill out to get adverse party served. If you know where he works, put the name of his work, what hours, and his home address, and any other information that you can give so that the sheriff can serve him, because it doesn't take effect unless he can be served. Also, I'm just going to do a quick warning about social media. Be careful what you say in those things, especially if you have children. It'll be used against you. And also, I mean, you can also attach things that adverse, if they're threatening you online. So that's my spiel. Hopefully you can help people get protection orders when they need it. And these are just, you can read all this stuff when you have more time, but hopefully that helps. Okay.
Okay, thanks, Elaine. I know you packed a lot into your 10 minutes. We are at 1 o'clock, and I do have court at 1:30. So I think we're going to end this. As Jenna said, though, all this information, I know Mark didn't quite get through the PowerPoint, but that PowerPoint's available to anyone who wants it. Just contact us, and Jenna will make sure that you can get that PowerPoint presentation. A lot of really good information there. So please do not hesitate to ask us for help. Again, this webinar was made possible because of City of Omaha ARPA Community Grant Program. We extend a huge thank you to the Omaha Community Foundation. Thanks to everyone who logged on today, and everyone have a great day. Thank you. Bye.
Thanks, everyone. And if you have any questions, feel free to send us an email and we can answer it for you if you didn't have time to put it in the chat already. So
do you want me to answer these chat? Can you
Yeah,
keep it up,
so
or how do we do that?
I'm gonna stop recording this.
Okay.